Hello, everyone. Welcome to our presentation today. We'll be starting shortly. We're going to be here with Rich Abdallah. He is an employment, real estate, and business law. So today our presentation is about renegotiating or litigating contract obligations in the wake of COVID. Rich, would you like to get started? All yours.
All right. So renegotiating or litigating contract obligations in the wake of COVID-19. I was thinking about this, and this COVID situation is pretty drastic. It reminds me of when we discovered polio, 60 years ago, and waiting in line to take a sugar cube with the Salk vaccine as a vaccine and preventative. I'll bet none of you have heard about polio in the US in 50 years, pretty much. But polio is still prevalent in countries like Afghanistan, Pakistan, and even Nigeria. Now, the reason I mention this is that the other day someone said we're never going to be completely rid of COVID-19. And it occurred to me that polio is kind of the same scenario. So we're going to be living with this for a long time. The question is, how soon are they going to have, or is there going to be a vaccine available, and how much damage is going to be done to society and to the business world, during that period of time. So, all right. So you've got a contract and you're in business and you're thinking, well, I can't fully perform on the contract, so what do I need to think about before going forward? So the first item to think about is whether your company's relationship with the other party is important to you. Is it the primary source of your service or product? Does it provide you with something that allows you to be unique in the industry? I'm sure you can think of many other scenarios, but if the company relationship, the commercial relationship with the other party is important, that's something to consider. Meaning that, boy, I would like to try to maintain that. I can't do it at the level that we were doing before, but I'd like to continue it at some level. And then when things get better, whenever that happens, I will, get back to normal, if you will. Another matter to consider. Next slide. Consider the amount in dispute compared with the cost of litigating the matter. Okay. I'm going to spend a little bit of time on this because I've handled business litigation for 40 plus years. And I'm always tell people lawsuits are not good investments. They cost a lot of money, and it's not just the attorney's fees. Lawyers in litigation will send these things called written questions. They're actually called interrogatories, but they're written questions. I've seen them run in the hundreds at times. And then you as the attorney have to sit down with staff and get the answers from staff typically. So that's a great, burden on the staff, or an imposition on the staff to answer written questions. You also receive these things called a request for production of documents. Sometimes the number of documents that are requested are voluminous. And of course, your client is going, why are we giving him all these documents, or why should we give him all those documents? So you have this ongoing debate, if you will, with your client about whether you should produce the documents. The clients don't want to do it, and they don't want to answer their questions. And because of experience, some of them have to be answered. Maybe all of them have to be answered. It's terribly time consuming. There's also a process called depositions. Deposition is a situation in which a person is brought into a room, given an oath, and the one or two lawyers are permitted to ask questions. Until about 3 or 4 years ago, these depositions could last indefinitely. I remember a deposition I had about 10 years ago went on for 4 days, and there was a week or two between each day. And I swear the lawyer must have gone back and revised every single question and re-asked the same question. Now there's a 7-hour limit for depositions. Well, that helps a lot, but what if the other side wants to take the deposition of your entire executive staff? So you have 7 or 8 people from whom will be taken out of their job, will be taken away from their office, maybe have to travel and be sitting in a room, usually in a library, for hours being asked questions. By the way, before they go into that deposition, of course, you as their lawyer will be spending plenty of time prepping them for that deposition. So those are things that are associated with litigation, answering written questions, providing documents, deposition taking, and so forth, which these processes will cost a lot of money because the attorney is involved in every aspect of it. And it will cost your staff a lot of time, all right? So it's not just the money. It's also how will this impact how you operate your business. Other things to think about, the time that it takes to get a matter from the filing of a complaint to a hearing before a judge or a jury is at a minimum 1.5 years. With COVID now, things are being pushed back, so it's probably more like 2 or 2.5 years. During that period of time, this is being hung over. It's hanging over your head. How is this going to be resolved? What if it goes this way? What are we supposed to do? What if it goes another way? What are we supposed to do? So you have this distraction from the business for a couple of years. What does that cost? Other than the attorney's fees, the cost is the stress on your staff and the inconvenience caused to your executive team. And here's another little goodie that you might want to think about. 95% of the civil cases settle. That's good. That's great. The problem is these settlements usually occur a week or 2 before the trial. At that point, your client has paid you $40,000, $50,000, $60,000, $70,000, maybe more. Some companies charge a lot more. And if you settled, you usually have to bear your own attorney's fees. So let me give you an example. Let's say you settle for $100,000. You think, okay, that's great. The case is over. We've settled. We spent 2 years in this litigation, but we don't have to go to trial on Monday. Here it is today, Thursday. We settled for $100,000, and then you look at what you paid the attorney. Let's say in my example, you paid the attorney $70,000, and you're going to have to bear those fees, meaning you're stuck with those, and the other side's stuck with theirs. So now your net recovery is around $30,000 in my example. So I don't mean to beat a dead horse here, but cost of litigation is time, stress on the staff, the attorney's fees, and last but not least is the uncertainty of who's going to hear the case. Judges are influenced by their personal backgrounds and by their jobs. So you may find a judge who is being unfair because they came from a particular background, maybe insurance defense or something like that. And their mindset, is that everyone who files a lawsuit for personal injury, is a liar, something to that effect. So, okay. So I've educated you or given you lots of reasons to bear in mind that if you want to go forward with litigation, there are a lot of things to consider. It's not a good investment, if you will, of time, money, or staff. So that's something to think about. Now, another thing I would add to that is if you're a small guy and you're dealing with a big company like an Apple or an HP, my experience is that the bigger firms tend to want to hire firms that are in the law firms that are sort of in their stature. So in other words, HP will hire the big shot law firm in Palo Alto that has 500 lawyers, and they'll put 5 lawyers on the case, and you're just inundated with discovery. So, you know, something to think about. Okay, so now I feel I've done my duty to tell you about why litigation is not a good thing to do. Now, sometimes you have to litigate. Sometimes your client says, fine, I'll pay you, and they do pay you. And you go to court and you take your risk and see what happens. So the first 2 items we talked about is, well, how important is the commercial relationship? What is the amount in dispute as compared with the cost? The cost, by the way, is something the lawyer can't control, the cost of litigation. The other side, as I said before, may pick a firm that just churns out this discovery. And, you know, if your lawyer gave you $50,000 as an estimate, now you're at $100,000, you're going, what happened? They go, well, they hired a big shot law firm, Palo Alto, and got 5 lawyers working on this, and they're going to bury us. I had a case one time with Tesla. When Elon Musk first came in, he fired about 40 or 50 people, and he may be a genius, but he's an idiot at times, because he said, oh, we're letting these people go because they're not up to our standard in effect, rather than saying we're letting them go because they don't fit the model that we're going to use, or we're looking for strengths or tasks or abilities that these folks didn't have. So we're changing now. Now he had to, you know how he is. He had to explain and justify the termination. At one point, I had 6 people in my office from Tesla. I ended up with 1, and we ended up settling. But the point I'm trying to make is that you know, it can be very difficult when you're let go by a company, but sometimes companies make foolish statements. The third matter to consider, after the cost of litigation, your relationship. Next slide, please. Is what is the potential reputation cost, if you will, to your company if it's engaged in litigation? If it's a high-profile case, it's going to get covered by the press. Now, I grant you that about 95%, maybe 99% of the cases don't get any attention from the press, but there are a few that do. So it's something to think about. I wouldn't let this particular factor really play a big role. I think it's much more important would be the first 2 factors, and that is, what is it going to cost us if we have to litigate? And 2, do we really want to have a relationship with this company and maintain it? If those 2 are, I think, more important than the potential reputational cost to the company. Okay. Next slide, please. Okay, now we're going to start to think about negotiating. The question is, should the company assert contractual defenses early or keep in reserve? Now, what we're suggesting here is, when you meet with the other company, do you want to immediately say, well, we think we can get out because of this particular clause in the agreement, or because the COVID has made our product temporarily obsolete or unusable for whatever reason, and our lawyer has told us that we can get out of this agreement without without any penalty. Well, we picked a couple of scenarios here. Scenario 1 is that you have no interest in negotiating. Frankly, if you have no interest in negotiating, or the other side has no interest in negotiating, you're probably going to end up in court anyway. Scenario two, the company wants to maintain a commercial relationship with the opposing company. That's probably more common than the other. Sometimes it may be an opportunity to get out of a relationship that you're stuck in. But if you're trying to maintain a commercial relationship with the company, and you have a contract, but you can't fulfill your obligations under that contract due to the COVID-19, you have to think about, what am I going to do to get through this time? The other question we have that I think I impliedly touched on at the beginning was, how long is this going to go on? We're now at 6 months. Is it going to be another year? I don't know. Nobody knows. So it's very, very uncertain as to where we're all going to end up. Next slide. All right, considerations for negotiation. And this is, I think, vitally important. Should a company business person or legal counsel assert contractual defenses, it should say, for example, impossibility or frustration of purpose? All right, so the business person is more inclined to maintain a fairly neutral, business-like tone in their negotiations. They probably know people in the other company they'll be talking to, and they may have been already engaged in negotiations. They may already have a very good working relationship with the other party. Then you have to ask yourself, will negotiations stall if legal counsel intervenes? Well, all right, you might want to use legal counsel if the opposing party is unwilling to negotiate, as I mentioned in the prior slide. If they say, forget it, we're not going to even talk to you, I don't think you have much choice at that point. You probably have to have the lawyer or your law firm write a letter saying, here's our position legally, and sometimes that can break the ice. Sometimes there's a big imbalance of power between the company and the opposing party. That's, like I say, if you have an HP on one side and you have mom and pop business on the other, that kind of imbalance is very hard to deal with, and you may need your lawyer. Defenses, some of the defenses need a detailed legal explanation. That's why the lawyer might be the person to be involved in negotiations. And there also might be there should be a possible need for pre-negotiations. That is a letter recontract defenses. There are a couple of ways you can do that. You can have the lawyer write the first letter and say, hey, we would like to negotiate, but if we can't reach an agreement, we think we can terminate the contract for the following reasons. I don't think that's the best way to go, and I'll explain in a minute. Next slide. Considerations for negotiations. How about, can contractual defenses be asserted without stalling negotiations or harming the business relationship? The tone in which you present these defenses is extremely important. If you're very aggressive, it may indicate that, well, we're probably going to end up in litigation. On the other hand, if you're mentioning the defenses in a way saying, I think we have possibly a defense here, it might be a legal defense to the contract, because, COVID, we can't provide the service, or nobody will work at the factory or whatever it might be. But we want to talk. That's probably the best way to do it. So in my opinion, if you start out with the legal defenses, and that's your first salvo to the other side, you're going to be creating a pretty negative atmosphere. But I'll explain a little bit more a little later how I think the sequence should be done. Okay, considerations for negotiation. Next slide. All right. Let's see. Consider negotiating business, personal, legal. Why don't you go over to the next one? Oh, no, go back to that one. There's a little mix up here. Okay. If the company has stronger defenses, legal defenses, contractual defenses. Those are interchangeable for our discussion. They'll probably put less weight on these defenses and more weight on trying to maintain the relationship. The company will want to negotiate, but should be ready to walk away if the opposing party takes an unreasonable stance. If the company has weaker contractual defenses, it's going to be very important that they understand that. And they take a look at that factor in deciding how to approach the other company. You'll have less leverage in negotiations, so you might not want to have an attorney involved at all. It's important to focus on the settlement and the relationship and the maintaining of that relationship. All right, next slide. Okay, I think the next slide is probably the best sequence of events or sequence of analysis that I can suggest. First of all, you have to assess all your debts. You have to gather the relevant contracts. Next slide, please. Third item is prioritize which debts should be tackled first. That's done in-house and that's done by the staff. Next slide. Oh, I'm sorry, no, go back. Now, engage inside or outside counsel to assess whether any obligations are excused or delayed due to contractual defenses. Okay, this is what I suggest. You talk to your lawyer, outside counsel or in-house counsel, and say, look, I want you to take a look at these contracts and tell me if here's what we do, here's why we can't meet the terms of the contract. Can you give us an opinion about whether we have contractual defenses to this? And if the lawyer comes back and says, I think you're stuck, I think you have a real problem here because your defenses aren't very compelling, then you know that going in there. And I think that will set the tone for your negotiations. The next item is assess whether to litigate or renegotiate obligations by weighing the three factors against the strength of the company's contractual defenses. Remember, those three factors were whether it was important to maintain the relationship. Let me go back. The costs of litigation, and finally the potential downside of publicity associated with litigation. Again, I wouldn't consider that a big deal, but in today's society, you can get on Yelp or whatever and say some pretty nasty things to companies. So there's some potential out there for negative comments to be made in the context of internet resources. Be cautious not to overstate the situation or explicitly or implicitly acknowledge any ability to pay debts as due. Finally, possible pre-negotiations letter. I think if you go to the lawyer and you have them write the first letter saying we're entitled to get out of this contract because we have these defenses, you can rest assured that the recipient of that letter is going to go to their lawyer, and then the lawyers are going to they're like, I don't know, peacocks, I guess. Oh no, he's wrong. Oh no, he's right. And I can beat that person in court and so forth. So, the lawyers are going to go back and forth. I've seen it 100, 200 times in my practice. So the better thing to do, in my opinion, is get that pre-negotiation letter for the company. Get some legal opinions first. Where do we stand on this? Do we have strong contractual or legal excuses, or are we not very strong? And should we bend over backwards to try to renegotiate something? that's my recommendation. Recently had a situation involving a lease, and in my opinion, my client being the landlord, the tenant had no right to terminate the lease because of the nature of the lease. We talked about this a couple of weeks ago. The lease did not limit them to using the property only for certain businesses, and they didn't. It was a way of getting out of the contract, and they wanted to. We knew they wanted to. So we settled the case in part because when I told my client it would be a year or two before we see the results, that was not very appealing. And secondly, I said, one of the big problems is this will settle because it's just about money, and the money amount is fixed. That's the rent. And you'll end up spending, $20,000, $30,000, $40,000 on attorney's fees. And if you got $60,000 in rent, now you're, you're really, you're $20,000 better off. So I think that's pretty much all I have to say at this point. Okay, we got plenty of time for questions. We'll just go for 15 minutes if there are questions. Okay.
So should I stop the share?
Yes.
Okay.
So are we going to, okay, there may not be any questions, which is fine.
Yeah. If anyone has questions, please raise your hand and we will turn on your audio so you can ask the question directly to Rich. You don't need to type it in the question and answers chat. About any questions you may have for Rich, he is here to answer anything you may think of.
Yeah, and I can't charge for this time, so take advantage of it.
So we will, we have a question, so let me go over there and allow play music to ask. Go ahead and ask your question. If you don't mind stating your name, that would be wonderful.
Oh, hi, yes, I'm John. My name's John, and we obviously give music lessons. Because of the county orders, much of our space is unusable. It was delivered to us with rooms, and we can't use those rooms because you can't have 6 feet of distance. Does that affect our contract? Do we suddenly have less usable space that we should be paying rent on in a situation like this when we literally can't have people in that space?
Well, let me start by saying, are you talking about the lease, or are you talking about a third-party contract with the people who buy your service?
Oh no, I'm speaking specifically of the lease.
The lease.
Yeah.
I had that exact situation. Client had a child care preschool, and they couldn't do it. They couldn't handle. You can't keep a bunch of third graders from 6 feet away from each other in that kind of a setting. So the business just evaporated, and they ended up having to close their doors. So what I understand you're saying is that, look, the rooms that we have are so small that we can't give music lessons in those rooms and still be in compliance with the 6-foot clearance. Is that what you're saying?
Yes.
Okay. Would it make any difference if you, are there any other spaces you could use, for example, in there? I take it they're not, or you would have mentioned that.
We have 6 rooms, and based on the 6 feet clearance, only half of the rooms are available to us.
Yeah, that's actually a good example of probably you're kind of in the middle. I mean, you can do some teaching, but you can't. The teaching you were doing, the music teaching you were doing before, not at the level you were doing before, so your income is down. So maybe you can negotiate something with the landlord. Whether you can completely get out of the lease, I'd have to spend a little bit of time with you. Are you teaching adults, or are you teaching children, or both?
Yes, both.
Both, okay. Yeah. I mean, your point's well taken. You have a government order that says you have to stay 6 feet away. You can't do that. That's what you're telling me. Is what I understand. It's impossible for you to do your job. Although I think you said that we could do it, but we could only teach about half as many people at a time. Is that correct?
We could only use half as much space and yeah, significantly fewer people. Yes.
It sounds to me like you're kind of you're really between a rock and a hard place. I mean, you can still run your business, but only at half speed, so to speak. So what I thought, what you might want to do is go to the landlord and say, look, I can only handle so many, and here's what I'm doing. Come over and take a look. Can we cut the rent in half, until, for another 6 months or until this is over? If he were my client, I'd say not until it's over, because none of us know when it's going to be over. But I don't think you can walk away from the lease, because you still can do, you still can conduct music lessons there, but you can't use it in the manner that which it was originally intended. So have you had a chance to talk to the landlord?
No, we were going to reach out to a lawyer first, and then.
I think, let me see if I can put this in 2 boxes. The first box is what's preventing you from doing what you did before, teaching in these small rooms, is a government order. Okay, it's not something that you said we would like to do that. It's a government order. That's step number 1. Number 2, to comply with that government order, we have to cut our teaching to half of what we were doing before, and that of course cuts our income. And I would try to renegotiate something with the landlord. If they're unwilling, come see me. I'll give you an hour's time at no charge.
I appreciate that. I have one sort of add-on question to this, and,
sure.
And I don't mean to take too much time here, but
no, it's all right. We got plenty of time.
The government order does specifically say if you're able to work remotely, you must do so. Which tells us that if we have any teachers that are able to work from their home, they must do so. Am I reading that correctly?
Well, I'm not familiar with that specific provision. You can't do it remotely. I mean, don't you have to be present with the student in order to provide the instruction? Yeah. I suppose you could take a look at the remote, but I don't think they're talking about the kind of business you're in. I think they're talking about, like a law firm or an office. You can do that work remotely. Are you able to remotely do music lessons?
Yeah, some are. We do it over Skype or
yeah.
In some instances you can, but you couldn't do it from the business depending on your instrument.
Well, that's what I was thinking. Maybe you can kind of recover more than half of your income by doing Skyping those people who want to do that. I mean, some people may prefer to do that. And I don't know if that's going to be 50% of your business and the other 50% come in, but sounds like to me like you're on the right track.
Okay, good. Well, I will reach out. Thank you very much.
Yeah, sure. Anybody else?
Thank you, John. If anyone else has a question, please raise your hand and we will unmute you.
Okay, no problem.
Okay.
All right.
So, well, thank you again, Rich, for taking the time and being here for us today and answering wonderful questions. We will do this again, and please everyone just visit us on our website and we will be able to tell you what is coming up next. Right. And so with that, we end the presentation for today. Bye-bye.
All right, my pleasure. Thank you for letting me convey this information that might be helpful to folks that are in our group. And another little thing the chamber, not a little, a big thing the chamber can do.
Thank you. Bye.